ladies and gentlemen. Thank you for standing by. Welcome to the Don't Be Left Behind, How to Manage Employee Leave webinar. Please note that during the presentation, all participants will be in a listen-only mode. Before we begin, we have a few things that we'd like to review with you. Before we get started, I wanted to remind you that you can use the chat box on the left side of your screen to interact with Sabrina and ask questions at any time during the presentation. We have a portion of the webinar at the end where we will answer your questions. If you're having any audio trouble, please message us in the chat box and we'll do our best to assist you. You will receive a copy of the slides via email from HR Direct in 2 days to catch up on anything you missed or you would like to review again. You can also join the conversation with us using the hashtag #EmployeeLeave on social media. As a reminder, this conference is being recorded Wednesday, August 5th, 2015. My name is Stephanie Thomas and I am your host on behalf of HR Direct. Thank you everyone for attending today's webinar. Today I am pleased to introduce to you Sabrina Baker, founder and CEO of Acacia HR Solutions. I'll now turn it over to you, Sabrina. Thank you for being here today.
Thank you, Stephanie. I am honored to be here. My name is Sabrina Baker. I am the founder and CEO of Acacia HR Solutions, which is a boutique HR outsourcing firm located in Los Angeles, California. We specialize in the full employee life cycle from recruitment to training and development to compliance. And we also have niche specialties in veteran hiring and federal contractor compliance. I was an HR leader for 11 years in a corporate environment before, ironically enough for today's topic, I went on maternity leave in 2010. About 2 weeks before I was supposed to return, my boss called and told me that I was laid off, and so we went through a reduction in force. And while on leave, my position had been eliminated. During that time, I decided to spend a little bit of time with my newborn son and then ultimately decided to open my own business, which I've been doing full-time since 2011. At the end of 2014, my family and I made a huge move from Chicago all the way to Los Angeles. My husband took a new job in Los Angeles, and we are loving it. It was a huge move and difficult to move an entire family nearly across the country, but we are definitely looking forward to our first full winter in Los Angeles and getting out of that Chicago winter. To kick off today's webinar, I wanted to talk about some of the current trends in leave laws. As you know, the United States is one of only a handful of countries that doesn't have any laws requiring employers of all sizes to give employees time off, aside from certain medical or religious reasons. Right now, there are some big pushes, especially at the state and local levels, to change this. The biggest talking point in this discussion is maternity leave, an area where we fall behind most of our peers. In 2014, the International Labor Organization, the ILO, conducted a study of 185 countries around the world. Of those countries, only the United States and Papua New Guinea lack federal public policies for paid maternity leave. The Family and Medical Leave Act, FMLA, is unpaid, and it only applies to certain businesses and certain workers. So many women and families aren't entitled to any leave from their employers. Of course, this varies from state to state. Some states have their own FMLA laws that cover more workers, and some states even require private employers to provide paid family or medical leave. But now that we're coming up on 2016, an election year, there's been a lot of talk at the federal level among different political players, including the current president, presidential candidates, and senators, about implementing paid maternity leave here in the U.S. This is shaping up to be a major issue, and it's one employers should definitely keep their eyes on. Another trend to watch, paid sick leave. Some cities and states, including California, Washington, D.C., New York City, and Connecticut, have already passed laws requiring employers to provide workers with paid time off when they're sick. In California, this just went effective July 1st. These laws all vary, but what they have in common is that unlike the FMLA, they cover minor illnesses where an employee only needs a few days or even a week off from work. Again, we're only a few months away from 2016, so expect to hear more talk about this. Right now, the Health Families Act, which would pass a federal law for paid sick leave in all states, which President Obama is urging Congress to pass, is sitting with a congressional committee and may be introduced in the House or Senate in the future. At the local level, there's an even greater push for paid sick leave. According to the National Partnership for Women and Families, there are 28 current campaigns across state, county, and city levels. This is definitely an issue you want to keep up to date on. Both of these issues are on the horizon, but for now let's focus on the current laws employers are already obligated to follow in regard to employee leave, plus some best practices and tips. For today's learning objectives, people take leaves of absence for all kinds of reasons, but the most common by far is due to medical conditions, which are covered under the FMLA. This is the only federal law that specifically grants time off for employees, but not every employer is affected by it, nor is every employee entitled to it. The FMLA is a complex law to follow, so I'll only have time to provide a brief rundown of the basics, including tips on how you can make it work in your favor while still giving eligible employees what they're entitled to. Outside of the FMLA, other laws may create loopholes that still require you to grant leaves of absence for medical conditions. So even if you're not covered by the FMLA, you may still have to grant leaves of absence for medical conditions. There are certain policies you can create now to help protect your business in the future and keep leaves of absence to a minimum while still treating your employees fairly during trying times. From there, I'll talk about how to prepare for a leave of absence. With the right preparation, any absence can be more manageable, but it requires planning across all levels: HR, management, teams, and the employee who's leaving. Finally, I'll cover how you can start transitioning an employee back to work. As you can see, we have a lot to cover, so let's get started. Today's webinar focuses on longer-term leave, where an employee may be gone for weeks or months. These kinds of absences aren't like an employee missing a day or two. When employees take off long amounts of time, it can really affect your business. So a lot of employers want to immediately deny requests, but that could land you in legal hot water even if you're not covered by the FMLA. Speaking of the FMLA, let's talk about that now. The FMLA is a complicated law, so before I start talking about it, I just wanted to get a feel for how many of you are covered under the FMLA or how many of you at least think you are. Since we're all in different locations, I'm just talking about the federal FMLA here. Different states and cities have their own FMLA laws, which tend to cover more businesses and workers than the federal law. On the federal side, there are very specific requirements for who's covered and who's not, on both the employer and the employee side. Okay, so it looks like most of you have started to reply, and many of you are definitely covered by the FMLA. We'll give you just a couple of seconds to answer. Those of you who are not sure, you are going to know over the next couple of slides. We're going to be covering who's definitely covered by the FMLA, so that should help you if you're not sure at this time. So over half of you have responded. Still looks like the most of you are definitely covered. Those of you who are not must be in the smaller business sector. We'll give you just another second to put in your answer there.
Hey Sabrina, we did close the poll, so we can move on now if you'd like.
Oh, awesome. Okay. All right, the FMLA was established in 1993 to allow employees to take reasonable unpaid leave for certain family and medical reasons. It applies to you if you have 50 or more employees on your payroll, including part-timers, temporary employees, and employees on leave, in 20 or more work weeks, which don't have to be consecutive, in the current or preceding calendar year. The FMLA also applies to public agencies, including state, local, and federal employers, and local education agencies, regardless of the number of employees. Assuming you're a covered employer, your employees are eligible for FMLA if they have worked at least 12 months and a minimum of 1,250 hours. Additionally, they must work at a location where at least 50 of your employees are employed within 75 miles. If employees are eligible, you must give them up to a total of 12 work weeks of unpaid leave during any 12-month span for certain reasons, such as the birth and care of the employee's newborn child, the placement of a child with the employee for adoption or foster care, the care of an immediate family member defined by the FMLA as a child, parent, or spouse with a serious health condition, and the employee's own serious health condition. Under the FMLA, a serious health condition is defined as an illness, injury, impairment, or physical or mental condition that involves either an overnight stay in a medical care facility or ongoing treatment by a healthcare provider. This serious condition either prevents the employee from performing his or her job tasks or the affected family member from attending school or doing other routine activities. Treatment for substance abuse may qualify, but only if the treatment is provided by a healthcare professional and other conditions are met. One way to make managing FMLA leave easier is to use a leave tracker. The Comply Right FMLA administration system includes one, plus necessary paperwork like FMLA leave request forms and medical certification instructions. HR Direct's Gradient's FMLA record-keeping software is a more comprehensive electronic solution that also includes the FMLA's military leave. Employees with a child, spouse, or parent on covered active duty status, or called the covered active duty status, in the armed forces, including the National Guard and Reserves, may also be entitled to a 12-week leave for qualifying exigencies. Qualifying exigencies include attending specific military events, arranging for alternative child care, taking care of financial and legal arrangements, going to counseling sessions, and attending post-deployment reintegration briefings. In addition, special FMLA leave entitlement allows eligible employees to take a maximum of 26 weeks of leave to care for a family member who is a covered service member during a single 12-month period. A covered service member is someone who is either a member of the armed forces who is experiencing and going through medical treatment, recuperation, therapy, and outpatient status, or on the temporary retired list for a serious injury and illness. A veteran who is a member of the armed forces at any time during the 5 years before the date of treatment and is going through medical treatment, recuperation, or therapy for a serious injury or illness. While the FMLA is the only law that explicitly requires employees to give employees time off, the American with Disabilities Act, which just celebrated 25 years, may create a bit of a loophole here. Under the ADA, which applies to companies with 15 or more employees, workers with physical or mental disabilities can request reasonable accommodations of their employers. In some cases, this may include leaves of absence. Just last month in July, the Equal Employment Opportunity Commission, who oversees ADA compliance, sued Dunkin' Donuts for disability discrimination. A regional manager at one of their stores was diagnosed with breast cancer and needed surgery. She asked the owner, this was a franchise owner, so they were not the entire Dunkin' Donuts Corporation, which would be governed by FMLA. Because this was a franchise, they were not large enough. She asked the owner of the franchise for 4 to 8 weeks of unpaid leave so she could undergo the surgery, chemotherapy, and radiation treatment. Instead of accommodating her request, Dunkin' Donuts fired her. According to the EEOC, quote, "Granting an employee unpaid leave for needed medical treatment is not only the compassionate thing to do, it is required by federal law unless the employer can show it would pose an undue hardship." So if an employee is requesting a leave of absence for their own disability, it may be covered by the ADA if it applies to your business. And the ADA has a very broad definition of what a disability is. Under the ADA, an individual with a disability is a person who has a physical or mental impairment that substantially limits one or more major life activity, such as walking, breathing, seeing, hearing, speaking, or, and this is important, learning and working, has a record of such impairment or is regarded as having such an impairment. By these definitions, a lot of major illnesses like cancer can be seen as disabilities, which makes the ADA applicable. Before denying any leave request, consult with your lawyer to make sure it's okay to proceed, or be prepared to prove that accommodating a request would cause an undue hardship for your business. When it comes to proving that a leave of absence would create an undue hardship for your business, documentation is critical. Keep close track of your employees' workloads to verify they're incapable of picking up extra tasks. I can tell you from recent experience, job descriptions come in very important here. Updated job descriptions, making sure that what is on the job description is actually what the employee does, will help in identifying undue hardships. You want to gather your financial records to show that hiring a temporary worker or contractor would be too expensive for your business. If the job in question requires technical skills, outline the essential functions and job description to validate that none of your current workers can perform the tasks, and finding a temporary worker would be difficult. Another way you can prove that a leave of absence would cause undue hardship is if reasonable, regular attendance is considered an essential job function. If the leave of absence would prevent an employee from performing the job's essential functions, and there is not another possible accommodation such as telework that would allow him or her to perform the job, the employee is not entitled to ADA protection. Under the ADA, a disabled employee must do the job adequately or be subject to discipline just like everyone else. Outlining leave of absence and attendance policies in your handbook can help reinforce the concept of regular attendance as an essential job function. If your policy states that you allow leaves of absence for up to a year, for example, and an employee requests an indefinite leave of absence, that may help you make the argument against reasonable accommodation. Requiring regular attendance for all employees can also help prove that the employee in question isn't able to perform the job adequately. The courts have ruled in favor of employers under these different kinds of scenarios, but it's still a good idea to double check with legal counsel before denying a request. A policy alone may not be enough to prove your case. Of course, talking about medical conditions poses its own set of precautions. It's important to handle these conversations in a delicate, sensitive manner. If you're the employee's manager or a supervisor, it's best not to get involved in discussions about specific medical issues and direct the employee to HR or upper management instead. If that's not possible, you need to be extremely careful with these conversations and the related documentation. If employees don't offer details about their medical conditions, don't push for specifics or ask for a diagnosis. Keep the conversation high level and focus on getting only the information you need to proceed. How much time off do they need? Are there any particular duties they feel would be too difficult for them to complete? Would it be possible to accommodate them in some other way? Whenever employees do share medical information, keep it confidential. Don't discuss details with other employees or colleagues unless they need to know. If a manager is involved in making accommodations or managing the leave of absence, for example, it may be appropriate to share certain information. If you have medical information on file, whether talking about medical conditions, treatment, or diagnosis, store it in a confidential file apart from regular personnel records. Another thing, employees aren't always aware of their rights. If they're asking for time off for a medical reason or to care for a family member, they may be entitled to FMLA leave, ADA accommodation, or other protections afforded by state or local laws, even if they don't mention any of these by name. As a manager, supervisor, employer, or HR professional, it is your responsibility, not the employee's, to know when the laws are triggered and how to respond. If an employee asks for time off for any FMLA or ADA-related reason, start taking the steps to verify eligibility and provide him or her with relevant paperwork. This may sound harsh, but the sooner you can identify the leave as FMLA, the sooner you can start counting down how much time the employee can take off. I focused a lot on medical leaves of absence, but I did want to circle back to general leaves of absence because there are other reasons why employees request leave. For example, certain types of leave may be covered under local laws, such as volunteering for the American Red Cross or assisting with other types of disaster recovery. Jury duty, which can potentially require a long amount of leave, may also be covered by local laws. Outside of that, employees sometimes request leaves of absence for personal reasons, such as pursuing an educational degree or training program. Whenever the reason isn't covered by a law, it's really up to company policy and your HR department whether to deny or grant an employee's request. In these cases, it's important to be consistent and objective. Don't create special rules or allowances for certain people, as this may be interpreted as discriminatory by other employees, which could lead to a lawsuit. Since so much of what we're talking about today depends upon your company's policies, I just want to go over a few ways you can use policies to protect your business and prevent employees from abusing leave requests. General leaves of absence are an employee benefit and are therefore entirely up to your company. Your policy can include any stipulations you'd like, such as eligibility requirements or limits for how long a leave of absence can be. You may want to also specify that requests can be denied or granted by the company for any reason or no reason, and that the final decision is up to the sole discretion of the employer. Some companies like to include a separate leave of absence policy and procedure for more serious events. Many companies call these catastrophic leave policies. For employees who've been the victims of violent crimes or who've lost their homes in disasters, for example, to distinguish between these and general leaves of absence. When writing out these policies, you may want to ease up on the eligibility requirements, but also ask for documentation to prove employees have faced hardship. Regarding FMLA, you'll want a company policy that outlines, at a minimum, employee eligibility, the circumstances, proper notice, and medical certification. Generally, FMLA leave is unpaid. However, eligible employees can choose to use or substitute earned or accrued paid leave, or an employer may require it. Unless state law prohibits it, you can require your employees to substitute paid leave as long as the practice is enforced consistently with all FMLA qualifying absences. To require substitution of paid leave, you must inform an employee of this requirement in writing within 2 business days of the employee's request for leave. Including this alongside your FMLA policy is also a good idea. You'll want to take into account your own policies and other state and federal laws when addressing FMLA in your workplace. An injured or ill employee may have rights provided by different overlapping laws that you must respect. If a state and federal law differ or conflict, you should follow the provisions most generous to the employee. One thing that I just wanted to add when it comes to general leaves is that it's very important to be consistent. Denying leaves for one reason for one employee and not another is not going to bring a good outcome for any kind of business. So you want to make sure that however you decide to approve or deny leaves, you're being very, very consistent across the board. The whole process of considering, approving, discussing, and managing a leave of absence can be a huge undertaking. But while you're handling requests, it's important to remember that your employees are human beings who may be facing incredibly difficult times in their lives. Even if you're frustrated with or panicked about their request, try to keep those feelings to yourself. Communicate with employees in a sensitive, compassionate manner, and be understanding if they're slow with returning any necessary paperwork. Providing documentation or attending meetings may be the furthest things from their minds. If you're missing anything necessary to provide them with leave, you can gently remind them of what you need from them. But the key there is gently. Try to be flexible and patient when dealing with them during this transition. As hard as their absence may be for your business, employees are likely facing even more difficult issues outside of work. You might be hesitant to grant a leave of absence since it seems so daunting to lose an employee for weeks or months. On top of that, requests for medical conditions can sometimes pop up with just a moment's notice. Whether you have a day, week, or month to prepare for an employee's leave, preparation is critical. Work with the time you have to start getting ready for the employee's absence. As soon as an employee puts in a leave of absence request, managers should take it to HR to see if any laws or company policies apply. If so, work within the confines of the law to start processing the request. FMLA, for example, requires specific paperwork and certification to qualify, so get the ball rolling immediately. If you suspect that the ADA may apply, start evaluating whether the leave of absence is a reasonable accommodation. You may want to speak with the employee to explore whether or not another accommodation would be possible, such as working from home, cutting back hours, or assigning certain tasks to other employees. If no laws or policies apply, it's the company's call whether to grant leave or not. Again, this decision will set a precedent for other employees, so carefully consider your options and document your decisions, including an explanation as to why you're granting or denying the request. Once the employee's leave has been approved, it's time to figure out what needs to be done and who will do it. Managers should make a list of critical job functions that must be performed while the employee is out, current or upcoming projects, and any other pressing work with deadlines that may occur during the leave of absence. Then meet with employees to see if there are any other assignments, tasks, or projects that need to be addressed during the leave. Prioritize the work for the employee so he or she knows what to keep doing or finish before taking leave. Again, the more time you have, the better, although obviously medical conditions don't always give you an advance notice. It's also a good idea to ask the employee to make a crib sheet on his or her work. Are there any processes to completing tasks, or does the employee know of any shortcuts? What about passwords others may need to know? Should any outside contacts be made aware of the employee's absence and referred to someone else? After finding out the employee's workload, managers need to assess how feasible it is to farm the work out. Meet with other team members or possibly coworkers in different departments, depending on the tasks, to determine who can take on any of the outstanding work. Find out if any deadlines can be pushed back until the employee returns. Identify tasks that may require training and have the employee coach his or her replacement before leaving. If there's any work that can't be picked up, or if the list is simply too long to pass on to other workers, it may be time to discuss other options, such as hiring a temporary employee or working with independent contractors or freelancers. You can always hire a temp to pick up basic yet essential tasks like answering phones, filing papers, or filing out invoices from current workers who can then be trained to take on more challenging tasks. Again, hiring an outside worker may qualify as an undue hardship for your business depending on the cost and your finances. Similarly, if the workers picking up the employee's tasks are eligible for overtime, and undertaking additional work would force them into overtime, that may also pose undue hardship to your business. Under the ADA, you would then be able to deny the request due to financial strain. In the employee's final days, make sure you take care of any required paperwork. Did they fill out any company-specific request forms? Do you have the medical certification? Is all other documentation in place? Once the paperwork is finalized, managers should meet with the employee again to verify how much work was completed. Find out if any additional projects or work popped up that need to be handled or reassigned. Make sure everything is on track and all work will be taken care of while the employee is out. If the employee has a return date in mind, verify that this date is still accurate. After all the nitty-gritty is taken care of, remember to put the human in human resources and give the employee some kind of appropriate send-off. If an employee is taking time off to pursue an educational degree or to adopt a child, celebrating with a card, cake, or lunch is nice. On the other hand, if an employee is leaving for a disability or serious medical condition, a public gesture would violate confidentiality requirements. Instead, something more personal like a handwritten note would be appropriate. Even after all your preparation, it's highly likely you'll need to get in touch with employees while they're out. Depending on the type of leave, there are certain guidelines you should follow. If the leave of absence isn't covered by any laws that restrict contact, it's reasonable to ask employees to check in occasionally, either through phone calls or emails, to answer work-related questions or provide updates on whether their return date will change. They may want to stay abreast of what's going on back at the office too, so check with them to see if they would like to attend any meetings either in person or through a conference call, or even social events like birthdays or holiday parties. After talking about that, I can anticipate a couple of questions about pay around when an employee is on leave. If they were to be working while they're on leave, do you have to pay them? And you could. The typical legal answer is it depends. If they're just checking in, if they're just calling for a minute or two to say that their return date is the same, or they're answering a question, you may not have to pay. If they're working for 4 hours, checking email, essentially working from home, then you could be required to pay them for that time. So that's just something to keep in mind, and I know usually something that pops up as a question. For leaves of absences that are covered by laws, approach the situation by asking employees what they feel would be reasonable and realistic. Will they be checking email? Do they want to be informed about significant events in the office? How much do they want to stay in the loop? Be careful in the way you handle these conversations. The employee will be on leave, not working from home, so make sure they understand that it's their call, not yours. Some people welcome distractions when facing difficult personal issues, while others prefer to avoid unnecessary responsibilities or interactions during trying times. Even if employees don't want to be contacted regularly with updates, it's worth keeping in mind just how much a simple "how's it going" or non-work related text message or email can mean to someone who's struggling. Employees may or may not respond to it, but just reaching out goes a long way in showing that you care about them and their issues, as well as letting them know you haven't forgotten about them during their time away. Assuming the leave of absence went smoothly and your employee is ready and able to return to work, you may want to take some additional time to bring them back into the fold rather than just throwing them into the thick of it all, so to speak. As we all know, in most businesses, 12 weeks is a lot of time and a lot of things can change. One way to ease the transition is to start reaching out to employees before they return. Schedule a call with them prior to their return date to confirm that they will be returning to work on that designated day. If their return will be delayed, take this time to find out how much longer they'll need, or if there's anything on your end that can be done to speed up their return. If the employee can still come back to work on the anticipated date, bring him or her up to speed on what's happened at work during the absence. Since the employee is still on leave, don't take too much time on the call and just focus on the most important changes. Once you've confirmed an employee's return date, start scheduling meetings with team members or other coworkers who took over any tasks during the absence. Ask these workers to provide updates on projects as well so the employee can see at a glance what's happened. You should also schedule a meeting between the employee and his or her manager, and a separate one for the employee and HR to review any record keeping or pay issues. Depending on the reason for leave and the employee's morale, you might want to schedule a team lunch for the employee's first day back, or even just leave a card or flowers on their desk. So to wrap everything up, let's just review the key points. While there is a huge push across all levels, city, state, and federal, to expand upon leave laws, currently there's only one law that explicitly requires employers to provide time off, the FMLA. If the FMLA doesn't apply to your business, the leave of absence may still be required if it's a reasonable accommodation for a qualifying disability. Unless you're certain neither of these laws nor any local regulations apply to your business or the requested leave, don't automatically deny requests for leaves of absence, especially not for medical reasons. Even if there are no laws that would require you to grant a leave of absence, don't forget the human and human resources and take the time to assess each request. Most employees only take leaves of absence when necessary, but you should still take action to protect your business from leave abuse. With the right policies in place, you can ensure employees who need time off are able to take it while preventing less scrupulous employees from taking advantage of the system. Part of the reason why employers are hesitant to agree to leaves of absence is because covering the employee's workload seems like an insurmountable challenge. With careful preparation, however, this shouldn't be an issue. Managers should take the time to work with the employee and figure out which tasks are most pressing, then shift responsibilities either to current employees or temps. To help ease the employee back into work, start reaching out to him or her a week or two before the designated return date to verify the start date and to update the employee on what's been happening in the office during the absence. Once the employee returns, meetings should be scheduled with workers who covered for the employee to update him or her on projects. Finally, take the time to welcome your employee back in an appropriate way, such as a team lunch or giving him or her a card. That is all I have for today, but I did see some questions come in from the chat box, so I'm going to go ahead and address those now.
Sounds great, Sabrina. You did a great job, and yes, we have plenty of time to cover all the questions that we see coming in.
Okay, I'm just going to scroll through here. Give me 1 second to read through some of these. One person just made a note that Washington, D.C. has its own FMLA law, which is more favorable than the federal FMLA. There are many states that have their own FMLA laws, and just like with overtime, with pay laws, with any other law, when you have a state law that differs from the federal law, you always abide by the one which is more favorable. So if your state law demands more than 12 weeks, for example, or it lowers the threshold for employer eligibility, so maybe your state law says if you have 15 or more employees you have to abide, then you always want to do the one that's more favorable to the employee. Catherine asked, if an employee is under a year of service, they are not entitled to FMLA. If they are out due to the birth of a child, can their position be eliminated? So there's a difference between that person being terminated and the position being eliminated. You can, even under FMLA in certain circumstances, eliminate a position. So for example, myself, my own example, I went out on FMLA. I'd been with the company for 7 years, so I was eligible for FMLA. I went out on FMLA, but during that time the company had a reduction in force where my entire position was eliminated. They were not replacing me. They were not they were completely eliminating that position. So even though I was out on FMLA, because they eliminated the position, that's legal. If you're asking more about can that person be terminated, then that question falls under your current leave policies that you have that are not FMLA, and it falls under your attendance policies. So if this person is not able to meet your attendance policy, if this person is not able to meet your other leave policies, then you could potentially terminate this individual. I would say, again, it depends. How close are they to being eligible? You do want to be careful, and if it's something that you could manage, then you would probably want to go that route. A couple questions here, it looks like, on eligibility. Part-time workers count, contract workers count. So if you have 50 employees, remember it's in a 75-mile radius, so not just in one location, but all of your employees, temporary employees, all of those count towards that 50. So it's everybody that you're paying in some form or fashion will count towards your 50 employee threshold in a 75-mile radius. Again, 60 employees, 45 are in one state and 16 are in another. If there's 75 miles, really for a 60-employee company, I would say you would want to follow the FMLA regardless of where the employees are, but typically it is that 75-mile radius. Doris asked, can an employee be protected under ADA after exhausting their FMLA entitlement? Yes, they can. So laws usually run at the same time, but there are certainly circumstances that could happen where an employee could be covered under FMLA and then also be covered under ADA after for an extended period of time. Now the key here is that it cannot create an undue hardship. So if an employee exhausts 12 weeks and now they need another 12 under the ADA, well, will that extra 12 create an undue hardship for your business? It very well may. So if you can prove that undue hardship, and that's probably the most important thing to be able to do, then you may not have to give any extra time, even if it's something that's covered by the ADA. Remember, with the ADA, they need to ask for the reasonable accommodation, and it needs to not present some kind of hardship for the company. Is childbirth considered a disability? Childbirth is covered under the Pregnancy Act, so it's an entirely different kind of ball of wax, and absolutely it is covered under the ADA. It's covered under the Pregnancy Act. It's covered under FMLA if your company is eligible. So it needs to be accommodated reasonably. So if you are not governed by FMLA but you have leave policies outside of FMLA, then pregnancy or childbirth would fall under that. Is the undue hardship applicable to an employer who does not fall under FMLA? The American with Disabilities Act applies to employers of 15 or more. So if you have 15 or more employees, then you are covered under the American with Disabilities Act, and you have to comply unless that request represents an undue hardship. Tia asks, how do you handle an employee who is sharing their medical information with others, their supervisor, admin, and coworkers, have told employee not necessary to communicate, but they copy others on emails? I think that I would make sure I have it in writing that you've asked them not to do that. It's their medical information, so it's their choice that they share, but I would make sure that I had a document that I filled out, that I signed, that they signed, that said, we don't require you to share this information with all of these people. Here are the only people you need to talk about this. If they continue to choose to copy others, that's it's their medical information, they can do that. But just to protect yourself from showing that you have never asked or required that they share private information, I think it's good to have documentation. We HR folks love our documentation. When is an employee eligible for the ADA? That is when they have a disability that is impairing them from doing their work, and it can be a temporary or permanent disability, and that is for any employer with 15 or more. Why is it important to remove employee medical records from employee files? Typically because medical records contain much more private information than personnel files. Also, medical records, medical files should only be available to people who absolutely must have the information. So your HR team, the person's supervisor would probably never have a reason really to comb through someone's medical records, but they would have a reason to look at a personnel file. Maybe they want to look at a past performance review, or they want to look at something on a person's application. And so the more people have access to personal files, and you don't want to have the medical information in there accessible to everybody who may be able to read it. Would a person who is requesting time off to go fight wildfires be a covered leave? That's going to depend on your leave policies. It very well could, but it's going to depend on what kind of volunteering policies you have. Is this person a member outside of work of some organization like the National Guard or the Reserve that requires time away? If it's some kind of military event, then it could very well be covered under leave. But if it isn't and you aren't governed by FMLA, that's not a military type of leave, then it's going to fall back on what types of personal leave of absence policies do you have. Let's see. Do you find that more companies are offering paid paternity leave? So that's very interesting. I don't know if you guys just saw in the news yesterday that Netflix has a new policy of 1 year paid maternity and paternity leave for the birth or adoption of a child. And so that's quite precedent setting because they're the first company in the States to do that. Obviously many other countries have paid maternity and paternity leave. I find that companies are doing more of a mix. So they are certainly offering if they're offering maternity, they're also offering paternity. But they are making it more, the paternity policies seem to be more unpaid, so maybe a week or two is unpaid. A lot of times I'll see these policies that are staggered based on years of service. So after 2 years of service, you get 1 week of paternity leave. After 4 years, you get 2 weeks of paternity leave, maternity and paternity. But I certainly see that being included more. I know early in my HR career it was strictly maternity, but now I am seeing a lot more paternity leave specified, and really they're just calling it parental leave. So regardless of whether you're maternity or paternity, it's just a parental leave. Here's the eligibility. Here's what you're able to take for it. Parents are included as immediate family members. Oh, that was a question. If an employee used all of his FMLA and still remains unable to return to work for an indefinite period of time, are we still obligated to provide him leave under ADA? That's kind of what I answered before. He may still be covered under ADA, but if his leave is indefinite, that's an undue hardship. An indefinite leave, I would think, and again, I'm not a lawyer, so check with your legal counsel, but I would think an indefinite period of time off is an undue hardship. Are these rules to be applied concurrently? Yes, they are. Is there a roster available that lists each state and what type of leave is available by law? I am located in California and would like to know what types of leave under which circumstances should be available to employees. So each state has their own site, either the DOL site, the ADA site. You can search by each state. In California, just because I'm here and I've had to learn all of the laws in California, which are so different than anywhere else, the Chamber of Commerce site has been a wealth of information for me on laws that are different than the rest of the states. But each state does a good job of keeping their websites updated with what the law is, and then of course the federal sites, the federal ADA.gov or the DOL.gov, those are great about updating all of these laws as well. Question about employee benefits. Under FMLA, you do want to, and especially in most states, they have the law that you do want to maintain benefits while an employee is on FMLA. You can require that employee to pay their portion of the premium. So if they're being paid vacation time or if they're being paid through any other method, you can take out the employee premiums as you always have. If they're not, if their leave is unpaid, you can require that they make the payments for their benefits while they're out, but you do want to keep their benefits active. And one thing that I would say is you want to have that clearly outlined in your policy manual. So under your leave of absence, whether it be FMLA or not, you want to have it clearly outlined what happens to their benefits, how long do they have before they need to get premium payments to you, all of those things. And so really, really thorough policies here are going to help you, and especially thinking about all the different scenarios and things that can happen, you want to have those lined out. Leanne asked, what about leave of absences that have no end date? Again, that seems like an undue hardship, so not something that employers, most of them can't handle indefinite leaves. So I would say that if they're eligible from FMLA, you do need to give them the 12 weeks. But after that, you're not required if it's going to be a hardship to give them beyond that. Can a supervisor email team members that their coworker is on FMLA leave without violating any HIPAA violations? So just saying that someone is on leave does not violate HIPAA or any other privacy laws. Certainly you wouldn't want to go into detail as of why. I would just send a short note that says this person is on leave. In their absence, please refer all questions or comments or needs to X person. So keep it short and sweet as long as you're not giving any specifics. Sometimes what I find happens in this environment is the minute you send out a note like that, people are asking you why, what's wrong with them, what happened, and just know that when those questions arise, it's none of their business, and you really want to be careful about what you answer. You did not mention short-term disability. Maternity is covered, which is mandatory in New York State as it is in many other states. Absolutely. So if you should be providing short-term disability, and pregnancy and maternity leave is covered. So employees would be eligible for short-term disability payments at that time. As an employer, if an employee is approved for leave, can we not take them off our systems and not allow access? I'm not really sure I understand what you're asking. You wouldn't want to take them off your systems. You want to keep them on your payroll. You want to keep them with their benefits if they have those things. If you're saying not allowing them to work, meaning you take them off of email, you take them off of the ability to check email or call in, or if you've given them a cell phone, do you disconnect the cell phone for that time? I've had those types of questions. You can. You want to be careful about that. I think the better solution is to really just lay out guidelines for them. Because there is a pay issue, you could have to pay them. So you may want to lay out very clear guidelines for them that says, here is what we're going to accept as far as you checking email or you using your cell phone for work time or whatever that while you're on leave, and anything else we deem unnecessary. Sorry about this. There's just lots of repeats, so I'm trying to find new ones.
Sabrina, you're doing great. We have time for a couple more questions.
Okay, awesome. Where can I find additional information regarding accommodating an employee with an extension of their leave? Do I ask them if they can return with restrictions? So if you're talking about an ADA leave, then ada.gov is a wealth of information. Just like I said, they just celebrated 25 years and they did a complete website overhaul with a ton of resources and information that will, FAQs and things that should answer a lot of your questions. You do want to talk to an employee about their leave, when they're expecting to return. Are they able to return to full duty, or do they need a modification to their duties? It's okay to ask those things, and it's their responsibility to tell you what those modifications are. And then you can decide whether they are undue, whether it's going to provide too much of a hardship on you, or whether it's something that you can accommodate. Remember that when you have state and federal leave requirements, sometimes they can run concurrent. Absolutely. When a leave does not qualify for FMLA and they simply state they need a personal leave for medical reasons, how much information can HR ask for? Should we have a similar form to the FMLA certification of healthcare provider? Yes, you should. Anytime an employee wants an extended period of time, so beyond a week, and they say it's for medical reasons, then you can ask for that certification. And using the FMLA form is fine, just changing it so that we know it's not an FMLA approved leave, but asking for medical certification so that you can know from the doctor what the leave is. You obviously don't want to ask for overly personal information, but just how much time are they going to need light duty? Is it that they don't need leave? Maybe they just need an accommodation for a couple of weeks. So you can ask for a medical certification, and I always encourage my clients, when you've had somebody out on leave, make sure you get a return to work. So make sure that you get a form from the doctor that says they are okay to return from work specifically for when it's been for medical reasons, because you don't want to have anybody working who was not cleared for the doctor.
Hi, Sabrina. I just wanted to add a clarification. That's even if you return from maternity leave as well?
Yeah, I usually ask for one returning from maternity leave, just clear to work. A lot of times what will happen is the doctor will clear a maternity leave before the person actually returns, especially under FMLA. So if I remember correctly, my child's 5 years old now, but I think I was cleared that I could return after 6 weeks or maybe even earlier, but because I wanted to take the full FMLA, I took 12. So just getting that doctor's clearance, sometimes there's complications with childbirth. Sometimes there are things that could create an issue where the person needed to be out longer, or maybe they need an accommodation now because of something that happened. So getting that return to work, I think, is really important. It just helps cover you. Again, it's just not asking for any personal information, just is this person okay to return to full duty, yes or no. And I think it just covers you that you've got them working back to full time. Okay,
we just got another question coming in that I think might be helpful to answer now. Does the employer have to pay the doctor for their time to complete the certification?
No, they do not. This is part of what doctors do. It's part of, they build that into the billing for all of us as patients. They build their time into that. It usually takes them just a couple of minutes, and the doctor normally doesn't even fill it out. The nurse or the assistant fills it out, and the doctor just signs it. So we as employers are not required at all.
Great clarification. We have about time for 2 more questions.
All right, let me find. What if the employee doesn't return after the 12 weeks and has not made any contacts, phone disconnected, and mail has been refused? Can we terminate the employee? Yes, you can. I would document all of the times that you tried to contact, the times that you tried to send mail. Obviously, you would have the return mail. So anything that you can document that shows we have tried, and not just a day, so not just the next day after they were supposed to return. I would give it a week, be reasonable with that time frame. But try and contact them, document all those times that you tried to contact them, and if you cannot get a hold of them, then basically that's job abandonment. So I believe you can terminate in that time. Let me take one more. Under FMLA, if an employee has a parent out of the country that they need to take care of due to serious illness, would this qualify? So this is an interesting question. I want to end here because unfortunately, this is one of those situations where it depends. I've had 2 scenarios pop up in the past 2 years with clients. One, an employee had a mother in another country who she was physically taking care of, not physically obviously because they were in different countries, but financially taken care of. She would fly back. She would use her vacation time to fly to the country every couple of months to spend time with her mother, make sure she was getting medical care. And so when she asked for FMLA to take care of her mother, we talked to the legal team at that time, and that legal team felt she absolutely did qualify because she had been supporting her mother for that long. At another time, it was a very different situation. There was no financial support back to the parents. There was really no proof that there was an existing relationship there, and so the legal team felt like we could deny the FMLA. So unfortunately in those cases it just really depends, and it can be very, very tricky when you're talking about out of the country. Here's what one of the lawyers that I talk to quite often always says is, look, if you as a business can accommodate it, do it. It's just easier. If it makes sense for the business, if you can, even if it kind of puts you off for a couple of weeks, if it's something that you can do, then you should just go ahead and do that. That's always going to be the best answer. If it creates the hardship, then that's when you should contact your legal team and say, are we able to deny this? But whether it be a reasonable accommodation, whether it be FMLA, if it's something that the business can reasonably handle, then you should just go ahead and do that as the business.
Great way to wrap it up, Sabrina. Thank you so much. This was a wonderful presentation. I hope everyone out there really enjoyed it. I know I enjoyed it. I do want to remind everyone, you will receive an email from HR Direct in the next 2 days with a link to the recording today. I know a lot of people were saying we got a lot of great information that we covered in the Q&A session. Can I hear it again? Yes, you can. We will send you a link to that recording and also a link to access the slide deck so that you can use these PowerPoints for future reference whenever you have questions about employee leave. Also in the follow-up email that you will receive on Friday, you will receive an invite to our next webinar brought to you by HR Direct. This will be on Tuesday, September 8th, 2015. Please note the different date. The September webinar will be Managing Employee Time and Pay, 7 Lies Employees Tell You and the Truths You Need to Protect Your Rights. Most employers have heard at least one of these demands from their employees, something similar to, you owe me overtime pay for last week, you can't make me work the weekend, or you have to give me paid vacation. Have you ever heard any of these things, and do you know if any of them are true? This webinar will explore 7 of the most common employee misconceptions about time and pay. We'll reveal the truths to you behind these demands according to the latest legal requirements. Just as important, you'll gain a better understanding of how to protect your rights as an employer with questionable time and pay issues while still doing right by your employees. This will be a great webinar topic, and also we'll have Allison Green joining us again. You may remember her. She worked with us in March on a webinar. and she's from the popular management blog, Ask a Manager, and she'll be joining us in September. Thank you all for joining us today. Thank you, Sabrina, for the great presentation. We really enjoyed it. Thank you, everyone, and have a great day.